Yes, good morning, counsel.
Good morning, Your Honors. May it please the Court, my name is Kevin Nixon. I represent Mr. DiPadova. I have two issues for your consideration this morning. I'd like to start with what I'll call the Berry issue, because that's the case that I'm principally relying on. The evidence in both cases, in my case rather, I'd suggest resembles the evidence in the Berry case, particularly as the evidence pertains to the expert testimony regarding criminal responsibility. That was a defense in this case, as it was in Berry. The defendant, Mr. DiPadova, like Ms. Berry, suffered from a long-standing and active mental illness at the time of the killing. The defense and prosecutors' experts both agreed to that. Where they differed was that as to whether his long-standing bipolar disorder with psychotic features that they both agreed included auditory hallucinations was the primary cause of the killing, as the defense expert had concluded, or whether his cocaine use was the driving force of the killing, as the prosecution's expert concluded.
The Commonwealth argues that not only that the cocaine was the driving force, but also that, and I think unlike in Berry, that there was ample evidence that the defendant knew that cocaine would exacerbate and or would bring on hallucinations, would bring on the voices.
There is some evidence of that, and there was evidence of that too in Berry. I think it was Dr. Vasile who had testified in that case that there was this, in her medical records, there was this evidence of chronic involvement in her psychoses and delusions and acting out.
But I think all she said was that alcohol gave her a buzz or something. I mean, it just seemed to me that this, or at least the argument is, this was different in that respect. But maybe that's my question. Is it different?
I can speak to that, Your Honor. I think the statement of the defendant that my sister is principally relying on is one that was made by the defendant more than 2 years after the killing, when he was meeting with the defense psychiatrist, Dr. Walter, or psychologist, excuse me. And at that time, he's expressing his understanding. Here he is, he's been arrested for the brutal killing of a woman that, by all accounts, was his friend, so to speak. They liked each other, and he did little chores for her around the house. 2 years later, he understands very well that having been relieved from cocaine, having been relieved from the conditions that were existing at the time of the killing, that in fact, yes, cocaine does play a role. It does bring on the voices. It did cause him, I think he said to Dr. Walters, he had no conscience when he was on cocaine. But that describes his understanding 2 years after the killing. I think the evidence that is in the record that shows what his understanding was at the time of the killing is not nearly so strong. In fact, when that very question is put to Dr. Walters, she says, yes, the use of cocaine exacerbated his mental illness. She's pressed on cross-examination, and she says, but it was not the primary cause of him hearing the voices. Now, that fits exactly within what the court had to say about this sort of defense in Berry, which is that the proper instruction, which was not given here, of course, is for the judge to inform the jury when you have a case like this with a defendant who's suffering from an active mental illness who nonetheless is using alcohol or drugs which tend to intensify the consequent conduct and the severity of the psychosis, then the jury needs to be told that so that they don't mistakenly disregard entirely the criminal responsibility defense, thinking that the defendant's voluntary use of cocaine, in this case, somehow defeated that defense. Now, that's what happened here. That's the other similarity here, is the use of the model instruction, which the court found inadequate in Berry, because it causes, in a case like this involving active mental illness intersecting with the voluntary use of intoxicating substance, the jury to conclude that the defendant's use of an intoxicant causes him to forfeit entirely that defense.
Did any of the doctors here testify that, in their opinion, the mental illness alone would have satisfied the requirements of McCool?
Yes. Yes, Your Honor. The defense, Dr. Walters was pressed on this, as you can imagine, and she she said as much on direct examination, and then when pressed by the prosecutor on cross-examination, she stuck to that opinion, saying that, and it's quoted at parts in the brief, Your Honor, that she acknowledged, again, that I think she even uses the words intensified and exacerbated. She acknowledges that the defendant's use of cocaine is intensifying the psychosis and conduct that flows from that psychosis, but she insists that the primary cause of his...
No, that's not what I'm asking.
I'm sorry.
Did any of the... Well, maybe I should change my question. Did any of the doctors testify that, in their opinion, the cocaine did not affect his... or that he would have satisfied the McCool test even had he not taken cocaine?
Yes, I think that's implicit or even explicit in what Dr. Walters had to say. She says in several places in the record that the primary cause of his killing his landlady was that he heard a voice saying, "Kill her." And then when she's asked about the cocaine's influence on that delusion and consequent conduct, she insists that it was the voice, not the cocaine. She actually explains that while one might believe, or one might ask, I think is the way she puts it, whether the cocaine was the cause of that rather than the mental illness, she says no, it was the mental illness, and the cocaine intensified the severity of what he was feeling and his consequent conduct, but she insists it was the mental disease that drove him to it. So the court... So this was not objected to, of course, and so the question, as it was in Berry, is whether this error created a substantial likelihood of substantial likelihood of a miscarriage of justice, and I'd submit that it did for the same reason that the court found it did in Berry, because Mr. DiPadova's jury, like Ms. Berry's jury, could have concluded that the defendant suffered from a mental disease that by itself rendered him substantially incapable. That would be if they had accepted Dr. Walters' testimony. But because he had consumed cocaine that contributed to his incapacity, that would render the lack of criminal responsibility defense moot. So in the circumstances of this case, just as in Berry, I would suggest that there does exist a substantial likelihood of a miscarriage of justice. Now, the second issue that is raised by this case involves the substitute pathologist's testimony. I know the court's looked at several cases involving this sort of an error, and again, there was no objection, so it's my burden to persuade you that there exists a substantial...
Was the conviction, I know there's an extreme atrocity or cruelty, was there also deliberate premeditation?
Yes, there was, Your Honor.
So I understand your argument about why this is a substantial likelihood or because of the extreme atrocity or cruelty, but how does it go to the
Well, I think
deliberate premeditation?
It hurts the defendant most as it tended to disprove or help the government prove that he was in fact criminally responsible. And this is explained towards the end of the brief, Your Honor. You've looked at the record, I'm sure, at least the parts that are reproduced in the brief so far, and you can see that practically the only thing that the substitute pathologist in this case did was convey verbatim the findings and conclusions and opinions of the pathologist, Dr. Evangelista. So Dr. Springer just reads basically his report, often saying, well, let me get this right, and then she quotes him. So there's no doubt that an error occurred of Nardi type error occurred when that was going on at trial. But among the things that she said that the prosecutor then, not improperly, but that he then used to suggest to the jury in closing argument that they should find the defendant was criminally responsible are Dr. Springer's testimony that there were defensive wounds on the victim's hands and arms. And that when she tells the jury that these are defensive wounds, again, she's just conveying what Dr. Evangelista had said. And then he uses...
Well, so that all you're telling us is there are two sides. There was a two-edged sword, but the other edge to the sword was something that the defendant really needed for purposes of his insanity defense, which was that he was in a frenzy and had stabbed the victim 100 times.
Yes,
That was critical to the defense, wasn't it?
Oh, I don't disagree with that, Your Honor. That the number of wounds was part of the defense, as you say, that he was in some kind of insane frenzy when he committed this crime. But the defensive wounds were, that part of the testimony was not used at all by the defense. It was...
Well, but once, the whole thing is going to come, isn't it? All of the medical examiner evidence about the wounds.
Well, it did all come in because there was no objection, of course.
But what I'm saying is the defendant needed at least some of that to support his insanity defense.
He did need some of it, and I'm not...
And the fact that there was a defensive wound doesn't really detract from his defense because, of course, if somebody's being stabbed, whether it's by an insane person or a person who is not insane, they're going to act defensively.
Well, the way it was put to use by the prosecutor in his closing is he suggested that the victim had, as you could see from the defensive wounds, that was evidence that she had fought for her life, and the bedroom rather, should have been in a bigger jumbled mess than it was. And he argued explicitly that the fact that night table lamps were standing up when the police arrived indicated that the defendant must have been sane enough to right them before he left the apartment. So I'm not complaining about all of the evidence that was admitted by the substitute pathologist, but I do have specific complaints about parts of it. The other thing that helped him argue for criminal responsibility, Your Honor, was he argued that the carotid artery had been severed, and that should have produced a lot of blood at the scene while the defendant was there. There was no other evidence aside from the substitute pathologist to put that fact before the jury. And he argued that that was indicative of the defendant's sanity because when the officer saw him later that night, arguably 4 hours after the event, he did not see any blood on him.
Well, was there blood in the body cavity?
The testimony was that she would have just bled out from the carotid artery being transected, Your Honor.
Well, but I mean, was there any testimony as to the order of the stabbing wounds?
No.
So the carotid artery could have been the last, as a result, the breach of the carotid artery could have been a result of the last wound.
It could have been, Your Honor. It could have been. But that's not the way it was argued, of course, by the prosecutor. No. The Commonwealth made use of this evidence by suggesting that the officer's observation of the defendant without blood on him 4 hours after the event indicated that the defendant was sane enough after having caused this bloody scene to clean up. And the predicate for that argument was the hearsay testimony offered by the substitute pathologist.
There were photographs, correct?
There were photographs.
So I guess I may be quibbling, but one could have made the same argument from the photographs. I mean, I assume the photographs also showed some blood, or were they just autopsy photographs?
No, there were photographs of her hands and arms. So I concede that my argument, at least with respect to that part of the...
How about the blood?
There was the evidence, the photographs of the room would not show that the carotid artery had been severed. They don't show nearly the amount of blood either that I think one can, infer from the pathologist's testimony. So there were photographs of the arms and hands, which were admitted with the assent of defense counsel. The other hearsay testimony, I think, harmed the defendant in that it helped the Commonwealth satisfy its burden on criminal responsibility and also tended to prove both theories of conviction.
And were there not other photographs which the Commonwealth did not or could not offer because they were viewed as unduly prejudicial?
Yes, that's right. There was a discussion at sidebar. The Commonwealth had hundreds of photographs, and by agreement with defense counsel, the parties agreed to admit only half a dozen, I believe.
Now, I guess here's my concern. If there had been a timely objection at the time that this was hearsay and should not come in, and if the judge had sustained the objection, the prosecutor then would have been able to argue, listen, I didn't get in, I don't have the person who did the autopsy, I need to show what the person who did the autopsy would have said, and I need to offer these photographs, and it would have changed the prejudicial versus probative balance.
I think that's true, Your Honor. I think that's absolutely correct. Of course, the case wasn't tried that way.
It wasn't tried that way in part because the jury heard the testimony that you're claiming
Yes,
is
Your
in
Honor.
violation of Nardi, which had not been decided at the time of the trial.
I agree, Your Honor. I'm here arguing on that issue a default standard of review, which is often hard for me to meet. I acknowledge as much, Your Honor. I think, though, the way that this case was tried permits the court, let me say that, to conclude that hearsay evidence, which should not have been admitted, played a substantial role in the Commonwealth's presentation and inferably played a substantial role in the verdicts that were returned by the jury.
Did the witness make any opinions? I mean, was she ever asked, do you have an opinion as
Yes.
to anything?
Yes, those are actually referenced in the brief as well, Your Honor. She offered, the only opinions that she offered which were admitted were about the amount of force it would have taken to transect the carotid artery and the amount of force it would have taken to avulse a tooth from the victim's jaw. She offered no other opinions that I saw of her own.
Didn't offer an opinion as to cause of death based on what she'd seen?
No, that's actually, again, it's reproduced in the brief, Your Honor. She says, they ask her, what was Dr. Evangelista's opinion regarding cause of death? And she says, let me get this right. And then she says, quote, and quotes his opinion regarding this sort of thing was repeated again and again during his examination. If the court has any other questions, I'd be happy to answer them. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Assistant District Attorney Bethany Stevens from Middlesex on behalf of the Commonwealth. And with me is Kevin Ryle, who's now retired from our office, but he was the lead prosecutor in the case. I'll start off with the Nardi issue, and I just want to make clear that this is not an issue of a lack of an objection. This is an express, on-the-record waiver of any confrontation with respect to that. Defense counsel made absolutely clear on volume 13, pages 16 through 19, of why he's not objecting to the substitute medical examiner's opinion about the cause of death and the nature and extent of the wounds, noting that the Commonwealth did want to get in the cause of death and the nature and extent of the wounds and could do so by the photos and having seen.
I know, I ask you this every time, but could you just slow down a little bit?
Having seen the hundreds of photos he actually put on the record, the overly prejudicial nature of them, and that he would not object to the substitute medical examiner's opinion. In addition to that, there's
where was that in the record?
That was volume 13 at pages 16 through 19. There's a further place in volume 11 at page 83 when there's a sidebar just about the scheduling of things, and the prosecutor tells the judge, this is my order of the witnesses, this is who I expect to be short and not so short. It looks like we've talked with defense counsel beforehand. There's not an issue with cause of death, so the medical examiner is going to be fairly brief. So there was conversations with defense counsel, with the prosecutor saying, look, I'm not going to have a problem with that. With respect to the cause of death, being read verbatim from the autopsy report, while that did happen on direct, cross-examination actually made that absolutely clear. On pages, and this is again in volume 13, at page 42, on cross-examination, it's defense counsel who says, I'm reading right here from the outline, and that severed carotid artery, that's the fatal wound. That's what it says here. It says multiple stab wounds to the head, face, chest, and upper extremities, fatal, near complete transection of the right common carotid artery. Don't I have that right? That's the outline I have. That's the only information I have. Isn't that right? And the reason he wanted to make that point, as well as stressing that we don't know the order of the wounds, is to defeat the extreme atrocity of cruelty prong of saying, look, that could have been the first blow. That could have been the fatal blow. And he absolutely makes that point. So this is not a situation where there was a mere lack of objection and the prosecutor doing it wrong. This was an agreement by defense counsel and prosecutor about how this evidence was going to come in.
Was the cause of death contested?
Not at all, Your Honor. In fact, and as you pointed out, the cause of the death was important for the defense. He wanted to show, and in his closing argument said, look, we've got a crazy guy here going, banging away and showing all the clusters 100 times is clearly somebody who's not in control of their capacity. So, and obviously the Commonwealth, the flip side of all evidence, the Commonwealth is going to argue, well, that shows extreme atrocity or cruelty as well as this premeditative, deliberate intent. So there was flip side to those evidence, but the defense counsel was strategically using that evidence. In addition to that, with respect to the defensive wounds, the medical examiner, the substitute medical examiner, was there not to render an opinion to cause of death, but to explain the information to the jury, to the lay people, about what the nature and extent of the wounds were. With respect to the defensive wounds, there were 4 photos that were admitted into evidence that were not objected to by defense counsel on authenticity grounds. Actually, he stood up and said, I believe the discussion about it, the testimony about the defensive wounds is volume 13, pages 25 through 27.
What pages?
25 through 27, and we're still in volume 13. When the photos come in on the defensive wounds, defense counsel actually stands up and says, I stipulate that they are a true and accurate depiction of the wounds as they looked. And then the Dr. Springer actually got up and explained, these are the wounds I'm talking about, different types of wounds. We have stabs, we have how deep they are versus how wide they are. Where these are on the arm, they would be putting up in a defensive wound. So she's explaining those defensive wounds, and that's clear that that's coming from her own experience and not just getting in Dr. Weiner's results. So there was absolutely no error, because this wasn't a lack of objection, so we should therefore look at this as an error. This is strategic on defense counsel's part, and so therefore could not create a substantial likelihood of a miscarriage of justice. There also is no likelihood that justice miscarried in this case with respect to the criminal responsibility issue. Unlike Berry, the evidence in this case warranted giving the activation instruction. The problem in Berry was that the alcohol evidence there was almost like prior bad act evidence that required a limiting instruction, as opposed to an instruction telling the jury that they might be able to do something with this evidence, such that they might be able to defeat a criminal responsibility finding by this evidence. Because there was no evidence of her knowing the effects of the alcohol on her, telling the jury that they might be able to do something with this evidence is what created the substantial likelihood of a miscarriage of justice. Because here there was substantial evidence of the defendant's knowledge of the effects of his drug consumption.
What do you say to Mr. Nixon's response that your argument is based on a statement that the defendant made 2 years later?
My argument is not just based on that statement. In addition to that, on July 29th of 2004, and this is Record Appendix 43, less than 48 hours when the defendant is giving his recorded statement to the police, he says, voices are more powerful or controlling when I'm on drugs. We also introduced into evidence, the defense introduced into evidence the medical records of the defendant's hospitalizations from 1996 through 2004, going all the way back to 1996 when he had an AdCare detox admission. There's a progress note, and I reproduced that at SRA 4, a progress note that says, quote, good insight, spoke with client about importance of sobriety in order to prevent worsening of illness. Another progress note in October of 2001 from the Taunton State Hospital, notes in that progress note, acknowledges significance of symptoms and risks of going back to substance abuse, and that's at SRA 6. There's another one from Lowell House Treatment Team in October of 2002 that he has insight as to how alcohol and drug use exacerbates mental illness. Another one from January of 2003, Lowell House Treatment Team, again noting, has insight as to how alcohol and drugs exacerbates his mental illness and symptoms. Then we also have the 2003 through 2004 PACT team hospital or progress notes that have continuing discussions. He's met every day by a community care worker in the community and then weekly by a psychiatrist. And those records show continuing discussions of the interplay between his mental illness symptoms and his drug use. So we do have absolute evidence here that would warrant giving the activation instruction, so that in the event the jury would believe that he was under the influence of a command hallucination at the time, the Commonwealth would have the ability, based on the McGrath line of cases, to disprove criminal responsibility by showing beyond a reasonable doubt that he knew the effects of consuming the alcohol would have on him, and that did exist here. So this is not the situation that you had in Berry, where there was a risk of an unforeseeable cause to this psychotic episode by alcohol. There was no basis for the jury to find that the defendant took cocaine and did not know of their consequences and just happened in this state.
Let me be clear on this. This case, of course, was before Berry.
It was.
If this case was tried today, are you saying that a Berry instruction would not be appropriate, or with the activation clause included, or are you saying that it would not be appropriate because of the evidence of activation was so strong that no reasonable jury could have found that?
I think that if this case was tried today, there would definitely be the instruction in Berry. Let me back up and say the court did not find that the instruction misstated the law or was in any way in error. It actually clarified the instruction. I don't think there would be any problem of having that clarified instruction given had this case been tried afterwards. But I don't think it was necessary to give that instruction, because what that instruction was trying to make clear is that any evidence of consumption of drugs doesn't matter. Disregard it from your criminal responsibility calculus. And then in footnote 9 it says, and if there's evidence, then give the flip side of that, that if the Commonwealth shows that you knowingly consumed or knew of the effects of the drug, then it could take away the criminal responsibility defense. But by telling the jury, you must find beyond a reasonable doubt that the defendant knew that ingesting these substances would cause this to happen, the flip side is being told to them. And if you don't find beyond a reasonable doubt that he knew that this was going to happen, then the criminal responsibility instruction still lies. So it's just clarifying. And the reason that it was so important in Berry was because there was no evidence of the knowledge of the effects. And so they really needed to tell the jury that evidence that you heard about alcohol really disregarded in your criminal responsibility calculus. In this case, you didn't need to tell the jury, disregard that in your calculus.
Was there any evidence in this case by any psychiatrist or psychologist to the effect that, in his or her opinion, the defendant would have met the McCool test as a result of his mental illness, separate and apart from his consumption of cocaine?
The defense expert, her opinion was that the voices were independent from the drug use, that it was a result of the mental disease or defect. But this is not a situation where, like Berry, there was any evidence to show that the defendant was at a lack of capacity state, like he was at a lack of capacity status, and that his consumption of drugs merely exacerbated that lack of substantial capacity status. In Berry, we had a situation...
Let me just ask my question again to make sure I understand what you're saying. Did any doctor testify that the defendant's mental illness or defect rise to the McCool level, separate and distinct from any use of cocaine?
That's what the defense was. That's what the defendant's expert was opining. She said that regardless of his drug use, it was his bipolar disorder with psychotic features and post-traumatic stress disorder that caused him to act this way.
So that the cocaine only exacerbated it?
Not even that the cocaine exacerbated. I mean, there was some testimony that it exacerbates his symptoms, but that he got to that level by the mental disease or defect. But she also didn't opine that he was at that level for any extended period of time. Unlike Berry, where she's in this prolonged delusional psychotic state observed before the murders as being irrational, during the murder, growling, incoherent, zoned out, goes back to the house. The police hear her. She rides the victim's bike back to her house.
Didn't the doctor testify that at the time of the commission of the crime, the defendant was suffering from a mental illness alone that rose to the level of the McCool standard?
At the time, she was saying that he was suffering from a command hallucination. There was no dispute that the defendant was bipolar, had post-traumatic stress disorder, had been diagnosed that, was diagnosed that before, during, and after. That diagnosis wasn't going away. The issue for the jury was whether he was under a command hallucination at the time. So had his mental disease or defect turned into this command hallucination, and then the command hallucination went away. So it wasn't like you had this lack of substantial capacity state, like I think the court was concerned about in Berry, and that alcohol merely exacerbated that state, but he was like already at that level. Here, we don't have that. We don't have the defendant acting in a lack of substantial capacity state and that the cocaine's just on top of that, because we have evidence of both before the murder and after the murder of him not exhibiting any signs of lack of substantial capacity. And his expert doesn't even opine that he didn't have the capacity before or after. She's just saying at the time there was a command hallucination. And so unlike Barry,
And that came about because of the mental illness, not because of drugs.
correct, right? And the Commonwealth's expert, and I just wanted to make clear too,
So why isn't that like Barry?
because in Barry, it was there was two concerns in Barry. One was the unforeseeability part, and then also that there was a substantial likelihood that the jury could have believed that the defendant lacked substantial capacity and consumption of alcohol merely exacerbated that lack of substantial capacity.
Isn't that what the defendant here is arguing?
No, he's arguing here that he got to that lack of substantial capacity just by the mental disease or defect, but not that he was at this existing state and his consumption of drugs just made him more that way. They weren't saying that he was lack of substantial capacity for some prolonged time.
That is what they're arguing.
Yeah.
This defendant isn't arguing that he was suffering from lack of, for a long time.
That he was suffering from his mental disease or defect, but it didn't rise to that level until right at the time of the murder.
So what? At the time of the murder, he was operating under the
activation-
impulse of a mental illness.
Right. I think, okay,
And not cocaine.
the concern in Barry was that it didn't address the unforeseeability part, and that's what the new instruction is that the court had set out there. But the court recognized in Barry that the model instruction, the activation instruction as set out in McGrath, does cover the situation where you have where, despite having a mental disease or defect, continue to have the substantial capacity to appreciate the wrongfulness of the conduct until the consumption resulted in the lack of substantial capacity. And we don't have a situation here. This is just so different from Barry, where Barry, you have a long-standing lack of substantial capacity that survives long past the murder. Here you don't have that.
That's just because it's a different mental illness.
I would suggest no. I would say it was different facts.
But isn't the key what happened at the time of the killing? Not what happened an hour before or an hour. I mean,
Right.
It may be important what happened an hour before, but it's not determinative.
It's not, but what the court kept saying repeatedly in Barry is that in the context of this case, on the circumstances of these cases, this is the concern that we have about what the jury might do with this evidence. The context of that case, and then the court is very careful about continually repeating that. This is a different context. These are not the circumstances here where you have his care workers who have seen him when he is in this psychotic state, in a hallucination state in the past, seeing him the day of the murder, the day after the murder, making the progress notes saying, thought coherent, not exhibiting, engaging in lucid behaviors. He's also then seen by people, Officer Finn, within 2 hours after the murder. Someone who had pink slipped him 2 months before had seen him when he's in this crazy state, not exhibiting any of those similar kinds of behaviors. In addition to that, we have Tony DeSilva, who is his friend who he ends up going to do more crack with after the murder, who has seen him.
Was there any psychiatric testimony or any history of him operating under one of these command impulses?
There was some suggestion that he had suffered command hallucinations in the past, a few of them being the result of cocaine, a few of them possibly being just from the mental disease or defect. But I want to make clear, too, though, is that the Commonwealth's expert did not opine that the cocaine was the driving force. The Commonwealth's expert opined he was not under a command hallucination at the time. It was an exaggeration. Again, there was exaggeration evidence in this case, and there wasn't in Barry. The circumstances of this case does not create a likelihood of a miscarriage of justice that this defendant was not criminally responsible at the time. Unlike Barry, both the observations of him before and after the murder and the murder itself, he's going there with a motive to get money for crack. He then commits the murder, puts a pillow over her head, steals her purse, cleans himself up enough so that when he sees an officer within 2 hours, doesn't have any signs that he'd just been in this brutal slaughtering, has a coherent conversation with a police officer who had just pink-slipped him 2 or 3 months before, who has pink-slipped him in the past and has experience and has knowledge of what his behaviors are like. We then have the person that he met up with an hour after that, Tony DeSilva, saying he was normal. We then have him interviewed by the police within 48 hours of the murder, giving in a completely exculpatory event about where his whereabouts were. He hadn't seen the victim for a week and a half, giving leads on other tenants that might be possible persons of interest. Then when he comes back again and he wants a detailed timeline about what had happened, he's telling you at 9 o'clock I did this, at 11:30 I did this, at 7 o'clock I ordered cocaine from the guy, and then I went down and did the cocaine on the boulevard, and then I did drugs with Mercedes, and all of these things were corroborated. This timeline that he gave was all corroborated. So there was overwhelming evidence that this defendant was criminally responsible for his actions and that there was no command hallucination. But to the extent that that the jury could believe there was a command hallucination, giving the activation instruction as it existed at the time clearly told them that the only way that if you do find a command hallucination and he lost a substantial capacity, the only way you can still find him criminally responsible is if the Commonwealth proves beyond a reasonable doubt that he knowingly induced that state. Because that goes right back to Sheehan and the idea that voluntary intoxication cannot be a defense to criminal or lack of criminal responsibility. If you knowingly induce that state, then you're still criminally responsible, even if you are at the lack of substantial capacity state. But unlike Berry, where there really was a real risk because of all the evidence that showed an ongoing lack of substantial capacity state, and that the alcohol just maybe exacerbated it, but didn't get you from below that level to above that level. Whereas here, you don't have that. You have a lack of substantial capacity state being opined by the expert to only occur once she says no to him. She says he went over there on his own volition. He told me he went over there to go talk with her. He told the police he went to go get money, or that the voices made him go get money. But he told the expert, I went there to go talk to her. She said no. I got angry. I turned away to walk away, and the voices tell me kill her. I immediately obeyed, and I went and got a knife, and I stabbed her, and the shit hit the fan. So it's not and then she said that, his then thinking that he needed to turn himself in suggested an appreciation for the wrongfulness of his conduct. He also, the voices said, good job, good job. So that's my, opinion of why he didn't. So there's no evidence like there was in Berry that, there really was just no circumstance like there was in Berry where the jury should have been told disregard the evidence about the drug. They should have been.
But why is there not an inconsistency between your two arguments? I mean, first you say he knew that cocaine made the voices worse, and therefore there's no substantial likelihood of miscarriage of justice, because if the Berry instruction had been given, the jury plainly would have found that he knew that the cocaine made his voices worse. And now you're arguing there was no evidence that even though he was on cocaine at the time, there was no evidence that he heard voices. I mean, isn't there a conflict between your two arguments as to why we should say this case differs from Berry?
I don't think so. I mean, I think the essential import of the Berry instruction was given in this case, because the Berry instruction is a clarification of the activation instruction. Really, all that the Berry instruction adds is it just makes clear if it was unforeseeable that this drug consumption would cause it, then you don't take it into consideration. He still is able to get a criminal responsibility finding, or lack of criminal responsibility finding. That's all the Berry instruction made clear, is that if you consume alcohol or drugs that causes you to lose your substantial capacity, you still get the defense. And then it just makes clear, so on Berry, on those facts, they just wanted to tell the jury, even though you consume the alcohol, disregard it from the criminal responsibility calculus. I'm saying on the facts of this case, that express instruction was not necessary. Not having that express instruction did not create a substantial likelihood of a miscarriage of justice.
Thank you.
Thank you.